Welcome to Law Girls channel. I'm Celes.
I'm Shuang. Today we are going to watch an opera.
Let's go.
I couldn't go to bed. My mind can't forget the snow in the bottle. Sleep, I couldn't sleep tonight because of the beer I drank tonight. I could have lived for loss, for the breach of contract, but I was not a party. I could have been healthy and done 1,000 things if there's no negligence.
One apple juice and ginger beer, please. Yes, ma'am. Okay. Let me try it first. Okay. That is ginger beer. It tastes a bit different today. Different? Yeah, I think it's really nice. We'll try and see. Yeah, it's a bit different. What is it taste? It is beer. Yeah. Do you want some more? Oh my god. What's that? Oh my god.
Okay, I saw.
Oh my god, what is this? This is snail! I drink a snail, oh my god. Did you see it? Are you okay? Wait. Oh, what is this? What is snail in our ginger beer? I don't know. It's not my fault. Oh my god. This is why it is here. Why? Sorry, man. Oh my god. It's snail. Snail in your beer. How can you imagine it? This is so disgusting. Oh my god. It's not my fault. It's from this. This is not my fault. Oh, are you okay? Are you okay? I'll bring you to see doctor. Come. Where's my condition now?
Mrs. Donoghue, I feel so sorry to tell you about. You have suffered gastroenteritis.
We'll hire a lawyer to sue the manufacturer.
My lord, my client, having sustained loss, injury, and damage through the fault of the defendant, is entitled to reparation therefore from the defendant. The shock and illness suffered by my client were due to the fault of the defendant. The said ginger beer was manufactured by the defendant and his servants to be sold as an article of drink to members of the public. It was, accordingly, the duty of the defendants to exercise religious care in order that Snail would not get into the said bottle, render the said ginger beer dangerous and harmful, and so with the said ginger beer. It was the duty of the defendant to provide a system of working his business that was safe and would not allow Snails to get into his ginger beer bottles. Such a system is usual and customary and is necessary in the manufacture of a drink like ginger beer to be used for human consumption. In this duty, the defendant culpably fell and my client's illness and shock were the direct result of his safe failure in duty. It was believed that the defendant's systems of working his business was defective in respect that his ginger beer bottles were washed and allowed to stand in place to which it was obvious that Snails had its freedom of access from outside the defendant's premise, and in which, indeed, Snail handling materials of Snails were frequently found. The The defendant will know that small animals like mice or snail left aerated water, including ginger beer, and decomposing there exceedingly dangerous and harmful to person drinking the contaminated aerated water. Accordingly, it was his obvious duty to provide clear ginger beer bottles so as to facilitate the safe system of inspections. In this duty, also the defendants culpably failed, and the said accident was the direct result of his said failure in duty. If the defendant and his said servants had carried out their said duties, my clients would not have suffered the said shock and illness.
My lord, the claimant evidence being insufficient to support the conclusion of the summons, the action should be dismissed. My client responded by denying that any of ginger beer had contained snails and that the alleged injuries were grossly exaggerated. Any illness suffered by the claimant was due to the bad condition of her own health at the time. In response to the writ, my client pleaded that first, the claim had no legal basis, second, the facts could not be proved, and third, he had not caused the claimant any injury, and lastly, the claim amount was excessive. The present case cannot be distinguished from the case of Mullen against Bar and Company, where the court held that manufacturer was under no duty to the consumer. The general rule was that a manufacturer owed no duty to the consumer with whom he had no contract with. To this rule, there were two well-recognized exceptions, which firstly, when the article was dangerous in itself, and second, when the article was known to the manufacturer to be dangerous for some reason. The present case did not fall within either of these exceptions, and the appellant was trying to introduce into the third exception, which food intended for human consumption and sent out by the manufacturer and sold to the consumer in a form in which the examination was impossible. There was no hint of any exception in any of the reported cases. There was no suggestion for the existence of a trap in the present case, and there was no logical reason for differentiating between articles of food or drink and other articles. Nevertheless, regarding to Donoghue's counsel argument, I hope the court can hold my client not liable.
Referring back to the statements of Mullen and AJ Bar Company, the only difference, and so far as I can see, it is not material difference between the case of Mullen and this case, Donoghue and Stevenson, is that they were dealing with a mouse in a ginger beer bottle, and here we are dealing with a snail in a ginger beer bottle.
A focus on precedent, although common law principles are capable of application to meet new conditions not contemplated when the law was laid down. These principles cannot be changed nor can additions be made to them, because any particular meritorious case seems outside their ambit. There are only the two recognized exceptions to the finding of a duty of care, and I would like to support Baron Alderson's judgment in Winterbottom and Wright, which stated that the only safe rule is to confine the right to recover to those who enter into the contract. If we go one step beyond that, there is no reason why we should not go 50. Therefore, I concluded that there was no common law support for Donoghue's claim, and I supported Lord Anderson's judgment in Mullen's case. In a case like the present, where the goods of the defendants are widely distributed throughout Scotland, it would seem little short of outrageous to make them responsible to members of the public for the condition of the contents of every bottle which issues from their vaults. It is obvious that, if such responsibility attached to the defendants, there might be call on to meet claims of damages which they could not possibly investigate or insure.
I agree with Lord Atkin that the duty of care a manufacturer owed to its consumer was the same regardless of the product they produced. It held that no general duty of care existed, and that the fact that the product was in a sealed container made no difference to the finding of such duty. Here, I quote from the consensus that Lord Atkin's broader test of liability would have opened the floodgates.
Looking at the fact of the case, Donoghue had no contract with Stevenson, nor that her case was covered by one of the scenarios in which a duty of care had previously been found. However, he held that where goods could not be examined or interfered with, the manufacturer had, of his own accord, brought himself into direct relationship with the consumer, with the result that the consumer was entitled to rely upon the exercise of diligence by the manufacturer to secure that the article shall not be harmful to the consumer. an exception to the general non-existence of a duty of care that applied to Donoghue. I would like to further argue that it was impossible to catalogue finally, amid the ever-varying types of human relationships, those relationships in which a duty to exercise care arises apart from contract, and he should be sorry to think that the meticulous care of the manufacturer to exclude interference or inspection by the seller should relieve the seller of any responsibility to the consumer.
Examining the previous cases, I would say that the law takes no cognizance of carelessness in the abstract. It concerns itself with carelessness only where there is a duty of care, when failure in that duty has caused the damage. Whether there was a duty and breach will be examined by the standard of the reasonable person. These circumstances must adjust and adapt itself to the changing circumstances of life. The categories of negligence are never closed. According to this standard, I would come to the conclusion that Stevenson had demonstrated carelessness by leaving bottles where snails could access them, that he owed Donoghue a duty of care as commercial manufacturer of food and drink, and Donoghue's injury was reasonably foreseen.
I agree with counsel. In my own research, Scottish and English law are identical in requiring a duty of care of negligence to be found. The general neighbour principle rule implies that you are to love your neighbour becomes a law. You must not injure your neighbour, and the lawyer's question, who is my neighbour, receives a restricted reply. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. Who, then in law, is my neighbour? The answer seems to be persons who are so closely and directly affected by my act that I ought to reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called in question. This was reaffirmed in the case of Heaven and Tender, and I do not think that it is favorable for cases to have a narrower interpretation of a duty of care, with the example of negligently poisoned food, for which there had been no claim against the manufacturer. If this was a result of the authorities, I should consider the result a grave defect in the law. And so contrary to the principle, I should hesitate long before following any decision to that effect which had not been in the authority of this House. I propose that there should be a duty of care owed by all manufacturers of articles of common household use, such as medicine, soap, and other cleaning products. I do not think so ill of our jurisprudence as to suppose that its principles are so remote from the ordinary needs of a civilized society and the ordinary claims it makes upon its members as to deny a legal remedy where there is so obviously a social wrong.
Hey guys! So, I guess you all have a rather clear idea of how Donoghue and Stevenson came about. Well, I can conclude that the outcome of the case is quite interesting, one of which would be the element of negligence. Now, in this case, we can see that the House of Lords affirmed that negligence is a tort. This means that a plaintiff can take civil action against a respondent if the respondent's negligence causes the plaintiff injury or loss of property.
Hey Celes, what are you talking about?
Oh hey, I'm talking about the principle of Donoghue and Stevenson. Do you have anything to elaborate?
Oh, you're blogging. What have you spoken about?
Oh, just the negligence element of the case. By the way, this is Gerjean, a great friend of mine from law school.
Hey guys! Well, another interesting element that emerged from this case is the duty of care principle. This is significant to prove the negligence factor of parties. And in the case of Donoghue and Stevenson, Lord Atkin's general principle established that reasonably foreseeability was a crucial element. Manufacturers have a duty of care to end consumers or users of their products. As per Lord Atkin's ratio descendi, manufacturer of products which he sells in such a form to show that he intends to reach the ultimate consumer owes a duty to the consumer to take that reasonable care.
The neighbour principle is a duty of care which should be owed where the defendant ought to reasonably foresee that his failure to take care may cause injury to another.
A duty of care will only be owed where there was an element of proximity in which the claimant was closely and directly affected by the defendant's conduct. The test of possibility of harm was necessary to prove proximity in the sense of close and direct relations.
Ah, I see. So, we can conclude that the neighbour principle opens the door to claims in negligence for injured parties by identifying the class of people to whom a duty may be owed in any particular scenario, right?
Yeah, however, we have to emphasize that the principle does not throw open the floodgates to unlimited claims, as a tortfeasor will not be held to owe a duty of care to those who are not close to be in his or her contemplation at the moment of tortuous act or omission.
Yeah, true. That's really true.
Okay, that's all for today. In our next video, we will be interviewing a law expert.
Remember to like,
Comment,
Subscribe
to our
channel.
Bye-bye.
Now, let us welcome Lady Gerjean Pepperoni, a law expert from Osnabrück University. She will be sharing her thoughts on the case of Donoghue and Stevenson. Now, I will pass my mic to her.
Thank you, Celes. Although the neighbour principle was a critical part of Lord Atkin's reasoning and was therefore part of the ratio of his judgment, neither of the other judges in majority expressly endorsed the principle. I therefore suggest that the case only supports the claim there can be duties in tort even if there is a contract, that manufacturers owe a duty of care to the ultimate consumer of their goods, and possibly that negligence is a separate tort. No amount of possible citation can of itself transfer with retrospective effect a proposition from the status of obiter dictum to that of ratio des standard. I find that the players in Donoghue left a continuing impact on the fine texture and local development of the law, but the impact of particular individuals must be measured and assessed in light of the pervasive social and historical forces in play of 1932 and soon after. To prioritize individual personalities over social forces as a general matter of historiographical principle is mistaken. Each interacts with and on the other. On another day and in another case, their involvement might well have been decisive. Accordingly, the article tentatively concludes that the precise interaction of the general social forces in play, the particular situational dynamics in law, and the characters involved can unfold very differently from one context to another. Donoghue is simply one chapter, albeit a significant one, in the further evolution of the common law. That's all for today.
Okay, that's all from Lady Gerjean today. It's such an honor to have her in our university. Now, we would like to invite her on stage to give her a token of appreciation.
In conclusion, this case, Stephen most statutory duty and evil
Wow, isn't that amazing?
Oh my god, they're coming! Let's take a picture of them. Hi!